Hi everyone, this is Jaimie in Human Resources. Today we're going to move forward with our series, Employment Laws That You Need to Know. And we're going to go over Family and Medical Leave Act, or FMLA. So let's get to it. First of all, what is it? So it is a federal law that protects employees for leave for their own serious health condition, to take care of an immediate family member with a serious health condition, for the birth of a child or placement to adoption or foster care, and then it also grants leave for caregivers of military personnel. FMLA can be continuous or intermittent. Intermittent could be tracked by the hour, by the day, and the time available they have is up to 12 weeks or 480 hours. And military personnel up to 26 weeks. So in most cases it's 12 unless it's related to military. They have to have worked for the company for 12 months in order to be eligible, as well as have worked at least 1,250 hours over the last 12 months. So if they've worked for the company for several years, but they worked part-time and didn't meet the 1,250 over the last 12 months, they are not eligible. And then additionally, they do have to work at a location where there are 50 employees within the 75 miles. So keep that in mind for our remote locations as well as our small branches. The FMLA does afford some protections for the employee. First of all, job restoration. They do have to be reinstated to the same or an equivalent position. That includes equivalent pay, job duties, job type duties, and then also the location. So you can't reinstate them to a position at another plant 50 miles down the road. That's just not fair. They also are entitled to keep their group health insurance benefits, and that is if they are making payment arrangements, and we do arrange for them to pay them while they're on leave, or also before or after. And then they have the right to take available paid time off, and some employers do require that. We do, unless they are on short-term disability or long-term disability. We do give them the option to take it or not. So be aware of that. Some exceptions. So they are not protected from action that would have been taken if the employee had not gone out on leave, as well as key employees don't have to be reinstated in some cases. These are going to be your employees that are CEOs, CFOs, your C-suite. So be aware. Other applicable laws with FMLA. So FMLA can get very complicated when there are other things at play. FMLA, ADA, and workers' comp sometimes all work in conjunction. Americans with Disabilities Act, ADA, that is the law that requires employers to make reasonable accommodations for employees with a qualified disability. The ADAA amended that act to broaden the definition of a disability. So if a employee has a condition that doesn't allow it, they aren't able to work or are restricted in some way and are under FMLA, they are very likely also covered under Americans with Disabilities Act. So be aware. And then also workers' comp, gives them compensation for a work-related injury, and there's also other laws that run in conjunction with workers' comp. If an employee is out on if they are out of their FMLA leave, keep in mind that these other laws may still protect them, and often the ADA has said that extended leave could be considered a reasonable accommodation. So we can't just immediately decide to terminate somebody who does not come back after 12 weeks of FMLA. Some things that you should know. First of all, as a supervisor, you are most often the first point of contact when it comes to the, for an employee to need to tell you that they need to take leave. And employees don't have to say that they need FMLA leave. They could come to you and tell you that they were just recently diagnosed with a health condition that will require them to be out, go to doctor's appointments, that kind of thing. So be on the lookout for any situations that may apply to FMLA. And reach out to Human Resources as soon as possible when this does happen, because we do have strict rules and timelines that we have to adhere to. So, for example, we do only have 5 days from the time that an employee tells us to when we have to let them know that they're eligible for FMLA. So be aware of that. And then there are some implications if we do not follow this law. Back pay, reinstatement, attorney's fees are all examples. Plus, we do have the potential, because of the ADA and Title VII, if they have a disability, they cannot be discriminated against for having a disability. And these kind of claims actually can get very expensive. I've seen them upwards of $100,000, and when there's multiple employees, it can get into the millions. So be aware. So there are 2 case examples that I'm going to go over. The first one is Lyle versus D.S. Waters of America. In this case, Mr. Lyle, he was on approved FMLA, and shortly after he went out, or in the meantime, while he was out on FMLA, the company was acquired by a new company. And that new company decided that Mr. Lyle would be part of a group termination, where they terminated him and also canceled his benefits. And of course, Mr. Lyle didn't like that. He was also, so he did sue. It's also important to note that 87% of the delivery drivers that worked for the old company were kept, and Mr. Lyle was one that wasn't. So that's almost 90% of people, and he was part of the only 10%. So that doesn't look very good for our company. So the court ruled that the company had a legal obligation to allow him to complete his FMLA leave and reinstate him to his position. So they settled, and he was reinstated, as I said, and received full seniority credit. So what that meant is he, for the time that he was there, plus the time that he was out, he got reinstated to full seniority. And then they paid him a total of $60,000. Part of that was back wages, as well as out-of-pocket medical expenses that he had to pay because they dropped their benefits. So, ouch, $60,000. The second one that I'm going to go over is Shell versus Tyson Foods. In this case, the employee, Mr. Shell, was kind of a jerk and had a documented history of policy violations related to abusive behavior. He'd been written up a few times, and the last straw was when, in an unrelated investigation, the employer found that, while talking to employees, that he was still doing this bullying behavior. And so, considering that and the history, they decided to terminate him, and being the jerk that he is, Mr. Shell sued and said that he was terminated in part for his leave that he took 3 weeks prior, FMLA. And the court dismissed the case. So, some implications from these 2 cases: make sure that you're not blocking employees' legitimate right to FMLA. Certainly don't terminate them and drop their benefits during the time that they're out. The court is not going to look too fondly at that. And also, don't be shy though. If you're terminating for documented reasons, if the employee is not meeting policies, not meeting expectations, don't be afraid to look at that. And also, plus, just document, write people up. That's why we come after you sometimes for those things. So the first case may have looked a little differently if Mr. Lyle had documented being that he was a jerk, like Mr. Shell. So, and that's all I have today. If you need directions or have questions, or if you think FMLA applies, please see HR. Otherwise, have a great rest of your week.